Welcome to week 3. This week's recorded lecture is on character evidence, pages 109 to 137 from your course book. The first case that we covered was Cleghorn v. New York Central. This is a Court of Appeals of New York case from 1874. This case was brought to recover for an injury sustained by the plaintiff, claimed as the result of negligence from the defendant's actions. The defendant in this case was a switchman, and the facts being that he failed to close the switch after a train was passing, giving an incorrect signal to an oncoming passenger train that the track was clear. The plaintiff in this case sought to introduce evidence that the defendant was frequently drunk and drunk on duty, and that his employer knew this. The issue in this case is whether evidence of the defendant's intoxications, whether that should have been admissible. This court held that yes, it was admissible. And this court looked to what this evidence was trying to show. So the trial court assumed it was to show that the defendant was a drunk, and therefore more likely he was drunk on the job, and then negligent at the time of the accident. If that were the case, it would have been inadmissible character evidence, as you cannot use a specific instance or prior bad acts to prove that conduct occurred on this occasion. So evidence that the defendant was frequently a drunk could not be used as evidence to show his character, that in this instance he was drunk and therefore negligent. However, the evidence was admissible on the issue of whether punitive damages should be entered against the defendant for knowingly keeping an incompetent servant. So if evidence was shown that the employer knew the defendant was frequently drunk and did not fire him, then they were knowingly allowing a dangerous employee to keep working, and that would be an issue when determining punitive damages. Once the evidence was admitted for this purpose, it is likely that the jury would consider the issue also for the defendant's negligence, but nonetheless it is admissible. So evidence admissible for one purpose is not inadmissible because it also goes to another issue. So because the evidence could be admitted on the issue of punitive damages, it's not then inadmissible because a jury might consider it towards inadmissible character evidence. In this case, a judge can give a limiting instruction to the jury, instructing them to only consider the evidence for that specific issue. The next case we covered is Michelson v. United States. This is a Supreme Court case from 1948. The defendant here was convicted of bribing a federal revenue agent with a large sum of money to buy influence. His defense at trial was entrapment. The defense called 5 witnesses to testify to the defendant's reputation for honesty and truthfulness, and then on cross, the prosecution asked whether the witnesses had heard of the defendant's prior arrest, and this was an arrest for receiving stolen goods 27 years ago. The issue was whether the trial court allowing this line of questioning was reversible error, and the Supreme Court held that the questioning was allowable for the limited purpose of verifying the witness's familiarity with the defendant's reputation, and this is consistent with how the trial judge did restrict the testimony. But in reality, like in the last case, won't a jury assume that the prosecution's questions about the prior arrests are true when there's actually no evidence admitted at trial regarding these prior arrests other than the prosecution's line of questioning? So even if a judge restricts the jury to only consider the testimony with respect to the issue of the character witness's familiarity with the defendant's reputation, isn't it likely that the jury will consider this as an independently probative piece of evidence and something that otherwise would have been inadmissible? So even though we know it's true that a jury might consider this testimony beyond the scope, the Supreme Court held here still that the testimony can be admitted. If you, in practice, are a defense attorney, this shouldn't stop you from objecting to these lines of questioning. A different judge, a different case, might find that the evidence or a line of questioning is too prejudicial and think that under FRE 403, the prejudice outweighs the probative value and exclude that evidence. When bringing a line of questioning, like in this case, a prosecution does need to show that they have a reasonable basis for believing the defendant actually did the bad acts they're asking about or was actually arrested for them. So they can't lie or make up a prior arrest to try and trick a character witness into saying that they do not know about a prior arrest and then questioning their credibility. But they also don't have to show outside evidence of the prior arrests. So a judge might ask the attorneys to come to the bench and discuss outside of the jury where the prosecution had learned of the bad acts and if they have a credible reason or a reasonable basis for believing that they're true, a judge can allow that line of questioning. Next, there are hypos on page 130 that we will discuss in class together, so please review these and prepare to discuss in small groups and then as a whole class. The next case we covered is State v. Arredondo, a Supreme Court of Washington case from 2017. This case involved a gang shooting where the prosecution introduced evidence of a prior shooting incident involving the same gangs in which were accused of having been involved in this crime. The accused was convicted. The issue here was evidence of that prior shooting inadmissible for prejudice? The state court upheld the conviction and concluded that the evidence was admissible to show the accused animosity towards that rival gang. They did recognize that this evidence was highly prejudicial, but concluded that the trial court was within its discretion to admit that evidence. The court also assumed that jurors would follow limiting instructions. There was a dissent in this case that argued that the evidence of the animosity between the gangs was actually evidence of propensity and therefore inadmissible character evidence, and also that the probative value of those prior incidents was outweighed in this case by the prejudice, especially given that the animosity between the rival gangs might have been established in a less prejudicial way, and this was also conceded at trial. And would you agree with this? We'll touch briefly on Proposition 8. This was an initiative brought in California in 1982 and passed, added to the California Constitution. This was the right to truth in evidence, where relevant evidence shall not be excluded in any criminal proceeding, except as provided by statute enacted by at least a 2/3 vote. So this prop did not affect the rules of privilege or hearsay, but was silent on character evidence, and saying that any relevant evidence shall not be excluded in any criminal proceeding seems to say that there would be no more excluding character evidence. However, the California Supreme Court held that California's ban on character evidence did survive this proposition because it was enacted by more than a 2/3 vote when it was amended in 1986, and so that is the only reason why in California character evidence is still excluded. The next case we cover is United States v. Cunningham. This is a United States Court of Appeals 7th Circuit case from 1996. In this case, the defendant was a registered nurse accused of tampering with Demerol syringes. The prosecution's theory at trial was that the defendant stole the Demerol from the hospital and replaced it with saline water. The defendant was one of 5 nurses that had access to the Demerol and then failed a urine test for Demerol. The prosecution argued that the nurse here in this case had an addiction and was the only nurse who, because she had access and failed the urine test, would be the only one who could have committed the crime. 4 years earlier, the defendant was also convicted of stealing Demerol from another hospital. The defendant's license was suspended after that incident 4 years ago, and then reinstated only on the condition that the defendant take regular drug tests. And then after that, the defendant falsified drug tests. The issue here is whether the trial judge abused his discretion in admitting that evidence of the defendant's suspension, falsifying the test results, and then evidence of her prior drug addiction. This would be evidence of prior bad acts under the FRE 404B, which we know are inadmissible. However, the court held here on appeal that they affirmed the trial judge's decision to admit the evidence. That is because the court felt the evidence of the defendant's addiction went to show her motive. Evidence of her suspension would give background to the jury about falsifying the test results to regain her license, and then falsifying the test results went to show the defendant's addiction, which was a motive, so a non-propensity reason for admitting character evidence. So some questions to think about with this case. So let's say you're the prosecutor and the defense argues that evidence of a defendant's addiction is admissible character evidence. What is your answer? So like in this case, addiction proves defendant's motive, and then motive is not character evidence. So let's say there's a prior incident of indecent exposure. And is that admissible to show that the defendant was guilty of also indecent exposure this time? So under the theory in Cunningham, yes, this motive is the unusual desire, the indecent exposure is unique enough to qualify as a motive. Most people are not going around exposing themselves, so this would be unique enough that, according to Cunningham, it would not qualify as inadmissible character evidence. So let's say that the defendant in Cunningham had stolen the Demerol to sell it for money versus for an addiction. The court would say that greed, wanting to make money, wouldn't be a unique enough motive to be excluded from the character evidence ban. So if there hadn't been evidence of addiction and it had just been stealing drugs to sell them, that's not unique enough to this crime. The court thinks that anyone would want to sell drugs for money, and then that would not point directly to this nurse or this defendant. And that is all the cases we had for this week. Next week, we will continue to cover character evidence. We will go into more detail on evidence of habit and admissible character evidence for non-propensity purposes.